All right, let's go back on the record in State of Arizona versus Lane Jeffrey Myers, IC 003692. Parties, please announce.
Rachel Stiles for the state, and Your Honor, the victim is present.
Good afternoon, Ms. Stiles.
William Parr, Mr. Myers, and he is present in custody.
Lane Myers.
Good afternoon, Mr. Myers. Go ahead and be seated, everyone. All right, so a couple of quick housekeeping matters. I do want everyone to know, just like yesterday, the matter is being streamed on the court's YouTube channel. So that is what's being done today as it was yesterday, so the public can have access to the hearing. Yesterday we did have a request under Rule 122H to record proceedings. What I want to make very clear is that under that rule it allows audio recording only, does not allow video recording. So the court wants to make it very clear here today that there will be no video recording of the proceedings in this matter. That said, I think we're ready to proceed. Mr. Parvin.
Yes, Your Honor. Defense would like to proceed to argument.
Okay, so Mr. Myers is not going to be testifying today?
No, we spoke about it, and he's shaking his head no, he's not going to testify.
Okay, and it's my understanding, Mr. Parvin, that you did have an opportunity to meet with Mr. Myers today in the courthouse prior to the proceeding. Is that correct?
Yes, and we discussed how this is going to proceed today.
Great, okay. I guess we're ready for argument. Ms. Stiles.
Your Honor, on March 14th, 2025, Mr. Myers was present for his arraignment, which was also his initial appearance, where he did receive release conditions in this case for felony offenses for which he has been charged. After that date, then he went and posted these two videos. These two videos from March 16th and March 17th were both done while he was on release. At the time, he did have the active injunction against harassment, which is an element of the aggravated harassment statute. As the evidence has shown, that injunction was served. It was in favor of the victim. It was served on Mr. Myers while he was in court, and it was still valid as of the date of these offenses. For aggravated harassment, we have to show that the defendant with intent to harass or knowing that he was harassing another person, and then it's that he communicated or caused a communication with another person by verbal, electronic, mechanical, telegraphic, telephonic, or written means in a manner that harassed. And so for that, he caused a communication because he went onto his YouTube channel knowing he has, over 15,000 followers. He went onto that channel and he posted the contact information for the work contact information for our victim, Shannon Walker. And the only reason that he would do that is because he's trying to elicit people to make the contact with her. He could have talked about his case without ever posting her information, but he put it up there clearly for all his followers to see so that they could see in the slapping style sanctions video where he's putting up her work address. And then in the other video, the public, I forgot the name of it, but publicly available public information video. He put that one up and that displayed her email address, it displayed her phone number. And both of those then caused the communication with the other. He knew that this would happen because he was on notice. As you heard from the testimony yesterday, Mr. Myers has acknowledged that he knows his followers reach out to the victim. He knows that this happens. So he's on notice of that. He knew the nature of the type of the contact they have, and so he's still doing it, so he's still eliciting them to then reach out to the victim. The definition of harassment means conduct directed at a specific person, which would cause a reasonable person to be seriously alarmed, annoyed, harassed, and the conduct, in fact, seriously alarms, annoys, and harasses the person. So we know it's directed at a specific person. This isn't just him talking about his case. He directed it specifically at Shannon Walker by putting up her information. So he's then calling on his followers to reach out to her because this is something he's had the history of doing this, of repeatedly putting up these videos for Shannon Walker and putting up the contact information so then people would reach out to her. And in fact, that is what happened. You heard some of the voicemails, you heard two of the voicemails that were admitted into evidence, and then admitted into evidence were some of the emails that she was getting that were in response that happened shortly after he posted these 2 different videos with her contact information. One of them specifically references, it was the gentleman who was coughing throughout, specifically references the content that was contained within that slapping style sanction video. And so it's clear that that communication was in direct response to that video. It references the University of Arizona, which is referencing the injunction that he put up. And while we only played a clip of that, the court does have the full video. And in the full video, he does go through and talks about that there was this thing in the police report that referenced the X, and that he talks in that video about that, and then that voicemail does reference that. So harassment, you have both the objective standard and the subjective standard. So you have the objective standard of what a reasonable person, would they be seriously alarmed, annoyed, and harassed by this conduct. And with the emails, the content of these emails is referencing, you know, her being raped, her being shot, things happening in front of her children, these voicemails of going to her home. This is all conduct that would cause a reasonable person to be seriously alarmed, annoyed, and harassed. And then you also heard Detective Brown reference that Shannon Walker is in fact seriously alarmed, annoyed, and harassed because she's afraid for her family, she's afraid for herself, so she has safety concerns. So we have both the objective and that subjective standard. And so these elements have been supported at this hearing under Article 2, Section 22. The standard is proof evident, presumption great. And we have the videos that were produced by Mr. Myers. So we have the evidence showing that he was doing this, the testimony indicating that he knew this is what his followers would do, that this has been going on for a period of time. So this is repeat communications. And then we have the result of what happened when he then caused a communication with another by causing his followers then to reach out to Shannon Walker. So for those reasons, we would ask the court to find that we've met that standard and to hold him without bond.
Thank you, Ms. Stiles. Mr. Parvin.
Thank you, Your Honor. Your Honor, as there appears to be many people watching this proceeding on YouTube, I'm going to explain a little about what this proceeding is not. This hearing is not about whether Lane Myers is guilty or innocent of any crime. This hearing is not about the 14 charges already filed with this courthouse. This court. The rules of evidence are more relaxed for this proceeding. This is not a trial on the evidence. This hearing is only about 2 alleged incidents involving YouTube. Both the United States and Arizona constitutions favor pretrial release. People are presumed innocent. People should not be in jail where it is incredibly hard to defend oneself. Arizona acknowledges this fact under the rules of criminal procedure and requires the least onerous conditions release necessary for the situation. Bail is a right in the state that should not be taken lightly. Before this court can deprive Mr. Myers of his right to bail, his constitutional right to bail, it needs to find that there is proof evident, both that Mr. Myers was in fact on pretrial release and that the alleged conduct was a felony. What is proof evident? Proof evident is more than probable cause. In fact, it is more than a preponderance of evidence. Although the courts have ruled the level of proof does not need to be beyond all reasonable doubt, unlike a jury trial, the courts have made it clear this is nonetheless a high standard of proof. It must be clear to this court that a felony was committed on pretrial release. Let's start on whether this even happened on pretrial release. The detective testified he thinks these videos were made after Mr. Myers was on pretrial release. However, the detective admitted he had no way of knowing for sure when the videos were made. He didn't know the time. He appears to be going off what he thinks YouTube may have labeled it as, but he doesn't know for sure. The state didn't submit any evidence of timestamps proving when these videos were made. Furthermore, the minute entries were not entered until March 17th. There simply was not time to enter anything on March 14th. The hearing ran late. It was heated. Security was here. Mr. Myers was escorted out to the situation because it was so heated and told to come back the following week to meet with pretrial services. Given this situation, how late it ran, as the court noted, we ran late yesterday too, it had to be continued, same reasoning. I argue that the proceeding was not official until the 17th when the minute entry was filed with the court and Mr. Myers officially knew his release conditions based on that minute entry, given how heated it was and had to be escorted out. However, the biggest argument here is that the conduct stopped. I asked the detective if there were any further videos reported. He said no, or not that he was aware, but it was a no. This means that once Mr. Myers was given his release conditions and on pretrial release, he was aware of them and stopped all conduct of these videos. Mr. Myers was not arrested on these new charges until March 20th, in court, by the way. He's doing his duty to come to court. He's always coming to court, never fails to appear. There were no videos posted on March 18th. There was nothing posted on March 19th. The conduct stopped pursuant to the detective's own testimony. Mr. Myers was summoned to go to court. He knew these charges were coming. He was understandably upset and exercised his First Amendment right to make some YouTube videos expressing his concerns. He was not on pretrial release when he received the summons. The fact that these videos stopped before he was arrested for these charges a few days later, that has to mean something to this court. This shows that the court's order of pretrial release was obeyed once it was official. This court should not deny Mr. Myers' right, his constitutional right to bail, on a timing of incidents so close together when the testimony shows the videos stopped. I am not arguing the state can't charge Mr. Myers for what they believe were contained in these new videos. I am arguing that there is no proof evident these incidents occurred on pretrial release. The conduct stopped. This court should not deprive Mr. Myers from his right to bail when the evidence shows he complied and stopped making videos. Next, I want to discuss whether a felony even occurred. The state argues that two clips presented to this court rise to the level of aggravated harassment. However, if the court reviews the state's own exhibits that they submitted to you, the email started March 15th. If the detective believes, but again, he's not sure when exactly, but if he believes that the videos happened later, then why did the emails in response to these videos start on March 15th? Either the videos occurred earlier in time, which means Mr. Myers was not yet on pretrial release, or Ms. Walker's email was already known to the public, in which case Mr. Myers was not responsible for what happened after. Or maybe it's both. But no matter which route the court prefers, it's the same result. There simply is no proof evident here. The state cannot meet its burden to deprive Mr. Myers of his highly important constitutional right to be released pending trial so he can defend himself outside of custody. Finally, there is the content of the alleged videos. In the first one, Lane Myers is simply defending himself and explaining a court document. Is the state really arguing that the explanation and posting of a court document listing the University of Arizona Law School's address somehow caused people to mail? Nowhere in that video did Mr. Myers tell anyone to contact Ms. Walker. He simply was explaining his legal proceeding and how he feels about it. That's not a crime. Certainly wasn't a felony. Maybe the court made a mistake in not listing the law school's address as confidential. Maybe it should have been. I don't know why the court, left that non-confidential on this injunction. However, if there was no mistake here, then certainly there's no crime in posting the address of a law school. The court should see this was a legal discussion in this video and had nothing to do with contacting Ms. Walker. In fact, the first thing the state mentioned was it requires intent. Clearly, there's no intent in that video to harass anyone. It's just explaining an injunction order and how he feels about it and how he's defending himself. The second video is admittedly slightly trickier. However, as the court saw, this video was silent. It was labeled public information. Ms. Walker's information was not the only one listed or displayed. The video went through several pages of the University of Arizona's website and showed numerous people and their credentials. If the court reveals the entire video, although we only saw a clip, even more names are listed. Public information. Now, it perhaps would have been more prudent not to post anything at all once the summons was received. With that being said, Mr. Myers has a First Amendment right to talk about his case and explain how easy it is to see public information online. If the video were solely focused just on Ms. Walker's contact information with instructions to contact her, that would be one thing. But it was a constantly changing video, as the court saw, flashing various things real quick, showing many people. That's not a felony. Now, lots of people were upset when Mr. Myers was charged. Lots of people watched the live streams as he was arraigned. As has already been established, lots of people must have already had her email. Or if they didn't, these videos were posted earlier and he wasn't on pretrial release. It's one of the two. Lots of people were upset. What we heard yesterday about what others, not Mr. Myers, third parties, I don't know from where, what these third parties, these people are doing, watching these videos, these commenting, what these emails, it's disgusting. It's despicable. I think it made us all cringe, myself included. That is just one of the most awful things I've heard said to someone. It's sad. No one should be doing this to people. However, it was very clearly established, including by the detective's testimony, that Mr. Myers was not initiating these emails or phone calls. Mr. Myers has never posted anything private about Ms. Walker. He would never initiate a contact like that. This isn't coming from him. These people have her email already. How they got it, I don't know. But it wasn't from these two videos. Now, I don't know if whatever Mr. Myers did in those already 14 charged offenses caused these horrible things that's now happening to Ms. Walker. They might have. Sadly, yes. I don't know for sure. Mr. Myers in the process of defending himself in all 14 charges. But whatever he did there, maybe that's what caused that. But that's in the past. That's not why we're here today. The only question today was, did these two new videos really rise to additional felonies? They really even committed while on pretrial release? They weren't, Your Honor. These two videos didn't add anything. At best, perhaps Mr. Myers may have violated the injunction and might be guilty, based on that video, of a misdemeanor crime of interference with judicial proceedings. But that is not a felony. It does not deprive Mr. Myers of his constitutional right to release, even if he is guilty, potentially, of the misdemeanor crime of violating that injunction order. With that being said, for all the reasons already mentioned, I ask that this court grant Mr. Myers release conditions here, because the state simply cannot meet their burden here to deprive Mr. Myers of such an important constitutional right to be outside of custody and defend himself. I'm not arguing the state can't pursue charges. They clearly have. They have some strong evidence for those 14 charges. They do. But Mr. Myers also has the right to bail. The state simply cannot take that away based on this evidence today, simply for these two extra videos that did not rise to additional felonies. Mr. Myers should be able to defend himself for those 14 charges And if necessary, these last two, which questionably may be additional charges, but not, I don't think there's enough proof for felonies here, Your Honor. And with that, I ask that you issue some perhaps quite stringent release conditions to ensure this, that everybody's protected here, the victim, but definitely issue release conditions. I think Mr. Myers deserves that. He's entitled to it. The state has not met their burden, Your Honor.
Thank you, Mr. Parvin. Ms. Stiles, last word.
Your Honor, the only thing Ms. Walker did in this case is she happens to be married to a prosecutor. She had no connection, as you heard in the testimony, to Mr. Myers, absent her relationship with her husband, that brought on that Mr. Myers then started this retaliatory smear campaign against Shannon Walker. He turned these people onto her. And so you heard testimony about the backstory, that this had been going on, that he had started posting on her and then causing his followers to be reaching out to her. He then, even though there was an injunction put in place, and the injunction tells him, do not have contact, do not cause contact, do not post her work address, he was put on notice of all of this. He is put on notice that this was happening to her, and yet he continued doing it. He didn't stop, he just kept going. And so then you hear that he's put on release, like he's at the hearing. So this argument that maybe he didn't know because it was a heated hearing, he was at the hearing in person on March 14th. He was present. That's when the court ordered the release conditions. That's when he was notified he is on release. He had his arraignment. He was informed of these felony charges. So he knew he was facing all these aggravated harassment charges, misdemeanor charges, the felony charges of aggravated harassment, a stalking charge. So he was on notice of all of these things. And as defense counsel noted, there were a lot of people that were very heated and upset about this. But what did he do? He went online again on the 16th and 17th, and he posted her information again, even though he had been on notice that this was causing all this harm to her, that it was causing these people that were following him to do this. And so he went into it. We don't have to show that that was his intent. The other standard is that he knew that he was harassing another person by causing a communication with her. So he is providing the means for those people to contact her by giving the address and the phone number and the email. So maybe some of them had it, but he was definitely making sure more people had it, because there would be no reason for him to be posting that information to those people other than calling on them to then contact her and take that anger that they had and direct it again towards her. Again, because he's retaliating for the fact that he is now facing these charges. You heard the detective testify that he himself, when he went on YouTube to get these videos, that he himself was able to see when these videos were posted. And then the court got the voicemails that then came right after it, showing that this was in response to what he was posting. So he was calling upon these people to do that. And this isn't where we just have to say in this vacuum of just these two charges, the history matters into what showing that his intent or his knowledge of this. And so that's why you heard the detective testify about that history, that he knew what the response was going to be. He did it anyhow. And so it meets that standard of that he meets both the objective and the subjective standard of causing that harassment to Shannon Walker. He caused that communication, knowing he had an injunction, knowing she didn't want to have contact with him, and knowing what his followers were going to do. And he did it anyhow, even with all that knowledge. And sure enough, it did exactly what he was setting out to do. She got that contact. She got those harassing emails. She got the harassing voice messages that scared her for the safety of her and her family, all because she just happens to be married to a prosecutor and had no other connection to this man. And so for those reasons, we're asking that you find the standard that the elements of showing that he was on felony release have been met, and the fact that the elements for the aggravated harassment, which is a felony, we have two different dates. The court only needs to find one, but the aggravated harassment was met, and we're asking you to hold them without bond.
Thank you. All right, folks, I'm going to jump off the bench, take a few minutes so that I have an opportunity to review the documents that were provided. I do intend to rewatch the state's exhibits with respect to the 2 videos. So give me about 10 minutes. I just want to make sure I'm very clear on what we saw yesterday before I issue my ruling. So stay seated. No one needs to get up. I will be back. Give me, I would say, about 10 minutes, and I will rule from the bench. Thank you, ma'am. No, I just want the admitted ones. Yep, thank you.
Well, this doesn't mean we can't. I need to get up and take a break. They'll let us know they can, right? I've used the restroom. Yeah, as good as it can possibly.
We're looking at the loyalty oath from the University of Arizona. All of the employees sign this oath. Allegiance to the solemnly swear, support the Constitution. And then right here, F. This is... We're looking at the... hold on. We've got the definition, basically. And let's go to the anti-slap. Oh. Oh, that's interesting. That really looks like some similar language. Yeah. Looks like a state employee to me. What do you guys think? This is Lane's bond hearing. Lane is there. She's about to come back with the ruling. He did not testify.
All right, and we are back on the record. I appreciate everyone's patience. I want to make sure that everyone knows what's been going on for the last, I think, closer to 40 minutes now. When the court got back in chambers, I wasn't able to view the actual CDs without a laptop, and one was not available for the court. So I did ask Ms. Stiles and Mr. Parvin to come back to chambers along with the iPad that the state used so that the court could view the redacted portions or the portions that were played in court. Once back there, counsel did ask the court to review states 12 and 14, which the court did. So I had a chance to view most of all of those videos. I will say that for states 12, that was the one from March 16th of 2025, slapping style sanctions. That one we did skip through. It was almost an hour long. And the portions that the court viewed with counsel in chambers were the portions that contained documents. There were several portions where Mr. Myers actually was depicted, I think, wearing a t-shirt and a hat, but the court did not view any portions of the video that had just Mr. Myers on it. So unless there was a document displayed on the screen, the parties did fast forward through that. So I want to make it very clear what this court has had the opportunity to review with respect to this case. So I did review states 12 in its entirety. And that one was about 16 minutes in length.
I think you said states 12. Is that? I think that's.
It should be states 12. I had the full clip says states 12 and states 14.
I just want to be clear, it's the publicly available public information is the one that you viewed in its entirety.
Yes, sorry, and that is, you're right,
So that was-
Exhibit 14.
Yes.
Yep, Exhibit 14 is the one from March 17th of 2025, publicly available public information. That is the one that was 16 minutes. That's the one that the court viewed in its entirety. There were no conversations between the counsel and court that had anything to do with this case other than literally looking at the videos and reviewing the information and the content that the court wanted to view before making its ruling on this case. Ms. Stiles, anything you want to add to the record that the court made?
No, Your Honor.
Mr. Parvin?
No, Your Honor.
All right. So the purpose of this hearing, and I think Mr. Parvin said it, this is not about whether or not Mr. Myers is guilty or not guilty of the charges that the state may be going forward with respect to this case. What the court is being asked to decide is whether or not Mr. Myers should be held without bond at this time. Arizona Criminal Rule 7.2 is very clear that defendants charged with an offense not eligible for bail under 7.2b1, someone is not eligible for bail based on a commission of a specified felony or any felony while on pretrial release. A defendant must not be released if the court finds that proof evident, presumption great that the defendant committed under B, any felony offense while the defendant was on pretrial release for a separate felony charge. That's what the court is having to decide today. In reviewing the evidence presented in this case, the evidence presented in Exhibits 6 through 10 do establish that Mr. Myers was on release on another felony matter when the offenses in this case were committed. What that leaves is whether or not there is proof evident, presumption great that the charges the state is going forward with today have been established. In reviewing the two videos, the first one, Exhibit 12, that's the one that occurred on March 16th of 2025, entitled Slapping Style Sanctions. The court will note that in reviewing that information, there was a portion of that video where Mr. Myers specifically talks about his X or an X and emphasizing the fact that there was an X. And as the state's evidence established during Detective Brown's testimony, there is a police report also shown in this particular video that makes reference to Mr. Myers as being an ex. I don't think that that's actually the case. That was the evidence, but that was the information that was displayed during this video on March 16th of 2025. That information is important to the court because not only does a caller later in that video actually call in and mention the fact that this appears to be retaliation for an ex or an ex retaliating for information. I think that specifically ties back to the fact that the viewers are responding to the information that was posted on March 16th of 2025 in the subsequent emails and phone calls that are made to Ms. Walker in this case. So I do think that the context of the information that is being displayed certainly ties back to the information that was presented with respect to this video. In that video, I will say there was a brief section that I did not review at all, from I think 117 in the video to 137 was something we skipped through in its entirety. So I don't know even the content that was on that particular portion of the video. So I want to make sure that I have that in there as well so it's clear what the court reviewed. In reviewing the information for the March 17th, 2025 publicly available public information that was 16 minutes, I will note that while there were a number of people that were displayed during that particular video, the initial portion of the video did display Ms. Walker's phone and email, as well as a photograph of her on the University of Arizona website. As the scrolling goes down through many of the pictures of other people at the U of A Law School, there is a significant pause when Ms. Walker's photograph and information comes up before he continues to scroll down through other people that were employed by the law school. There are many times during this 16 minutes where he stops and focuses specifically on Samantha Walker, her achievements.
Your Honor, Shannon Walker.
Shannon Walker, I'm sorry. The fact that she was a key contact at the law school. I will note that there was a portion where there was a focus on, very briefly, Samantha Walker, which is a different person, that was also stopped on again very briefly, but it was very clear during this 16 minutes that he continued to focus on Shannon Walker. There was, in fact, a portion as he was scrolling through where there was a photo of Miss Walker with her husband and her children, where she is shown as a member of the board of directors, and again, very much focused on her throughout that 16 minutes from the March 17th, 2025 video. Mr. Myers has the YouTube channel where a number of people follow. Based on the entire context of the communication in this case and the information provided to the court, I do find proof evident and presumption great that Mr. Myers did commit these offenses. That's only for the purposes of, obviously, this hearing as it pertains to the aggravated harassment involving Ms. Walker on these two videos, so those two counts. And again, looking at ARS 13-2921, harassment, as the state pointed out, a person commits harassment if the person knowingly commits any one of the following acts in a manner that harasses. Under A1, contacts, or this is the part, causes a communication with another person by verbal, electronic, and other means. It is the electronic means in this particular situation. And under E, it defines what harass means: conduct that is directed at a specific person that would cause a reasonable person to be seriously alarmed, annoyed, humiliated, or mentally distressed, and the conduct, in fact, seriously alarms, annoys, humiliates, or mentally distresses the person. There is no doubt, and I think even defense conceded, that the contacts with Ms. Walker in this case are truly offensive and would certainly cause a reasonable person to be annoyed, alarmed, and distressed, mentally distressed. The aggravated harassment statute under 1329-2101 requires that a person commits aggravated harassment as provided in the underlying statute that I just related, and at the time of the offense, any of the following applies. Under A1B, an injunction against harassment pursuant to 12-1809 was issued in this case and was enforceable. For those reasons, the court does find that Mr. Myers is going to be held without bond today. Anything else that we need to do on this matter from the state's perspective?
No, Your Honor.
Mr. Parvin?
I was just saying, if the court's finding proof evident, can we go straight to arraignment so we can start the 150-day timing? I'm wondering if instead of waiting 10 more days, I understand there's an indictment coming already. I'm saying if the court's found proof evident, that's more than probable cause they're getting. If he just wants to have a speedy trial rights and start the 150 as soon as possible.
Ms. Stiles?
Your Honor, the charges are still set to go to the grand jury, so that process hasn't happened yet, so we don't have the charges to be able to do an arraignment today. If they're wanting to waive a probable cause determination, there are forms that we can prepare to do that. So that's up to, but I'm going to say there's going to be additional counts that go through as well. But I can present those to the defense. If he wants to waive the probable cause determination, we can do so. If not, it will be proceeding to the grand jury.
I think the important, I think it's 10 days. I know we're at March 31st, still some time there for that to be done. But Mr. Myers does want to invoke his speedy trial rights and wants the 150 to start as soon as possible.
Understood, and I think for purposes, again, of this hearing, the court only has to consider one charge. I think the state does have the ability to go forward on other charges, and it does sound like these may not be the only two charges that the state does intend to proceed on. So I'm sure Mr. Myers and Mr. Parvin, you obviously will continue to assert his rights going forward. Anything else that we need to do today?
No, Your Honor.
All right.
No, Your Honor.
Thank you all.
A lot of people here, but speedy trial will start around.
Shouldn't have been settled on the side of the road. No fuck, shithead! You're not kidding, are you? Because he went to court in September trying to defend his mother, and John Carl Lanchowski took that away because he wears a black fucking robe. Stick your robe up your ass, John Carl Lanchowski. You guys need to be cursed. I hope your dicks fall off. I hope your dicks fall off. And I hope that you get fucking cancer and die. You're worthless pieces of shit. I'm just wishing that happened.
Whoa, whoa, whoa. No.